After 50 years of being the law of the land, the question is, why was Roe overturned? Today, you will understand the law and the facts behind this ruling.
My name is Nathan Laurie. If you are new here, we talk about the law and the facts. If you're about that life, don't forget to like this video, share this video, and subscribe to the channel.
Now, many legal academics were concerned about the reasoning of Roe from the beginning. Here is Ruth Bader Ginsburg explaining it.
When President Clinton became president, you were obviously somebody being considered, and then President Clinton talked to somebody who was pushing for your appointment, Daniel Patrick Moynihan, and President Clinton said, well, women don't want her. Now, how could that have been the case when you were the leading lawyer in gender discrimination? Why would women have not wanted you, or some women not wanted you on the Supreme Court?
Just some women. Most women were overwhelmingly supportive of my nomination. But I had written a comment on Roe v. Wade, and it was not 100% applauding that decision. What I said was, the court had an easy target because the Texas law was the most extreme in the nation. Abortion could be had only if necessary to save the woman's life. Doesn't matter that her health would be ruined, that she was the victim of rape or incest. I thought Roe v. Wade was an easy case, and the Supreme Court could have held that most extreme law unconstitutional and put down its pen. Instead, the court wrote an opinion that made every abortion restriction in the country illegal in one fell swoop. And that was not the way that the court ordinarily operates. You know, it waits till the next case and the next case. Anyway, it was that some women felt that I should have been 100% in favor of Roe v. Wade, and because I wasn't.
Now, in 1973, Roe v. Wade was decided under the principle of this right to privacy. Now, the right to privacy will not be found in the Constitution at all. Now, in the Roe v. Wade opinion, the court mentions that the Constitution does not explicitly mention any right to privacy. So, how do we know what rights are protected in the Constitution and which are not? So, since this right to privacy is not within the Constitution, then how do we know what rights are protected within the Constitution? Well, there are two ways. First, we have the enumerated rights or the written rights. Now, these are rights that are just written in the document. For instance, your freedom of speech, the First Amendment, or your freedom of religion. Those rights are listed within the Constitution. Simple enough. But then, what about unwritten rights or unenumerated rights, like the right to privacy from Griswold v. Connecticut, or the presumption of innocence from Sandstrom v. Montana? What authority does the court have to create these unwritten rights from whole cloth? What does the Constitution say about unenumerated or unwritten rights? Well, we look to the Ninth Amendment, which says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So the authority for unenumerated rights within the Constitution actually comes from the Ninth Amendment. Now, this makes sense because when you start listing rights, you may miss something important. So the founders of the Constitution said, well, let's not make this an exhaustive list and leave wiggle room so if other rights are discovered, they can also be protected by the Constitution also. But now, this is the main question. Who decides what those unenumerated, unwritten rights are? The Supreme Court. In a case from 1803, Marbury versus Madison, Chief Justice John Marshall, in the greatest power grab in American history, decided that the Supreme Court determines what the law is. And here is his reasoning for it. From the landmark case Marbury v. Madison, it is emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to a particular case must of necessity expound and interpret that rule. If two laws conflict with each other, the courts must decide on the operation of each. So if a law be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must either decide that case conformably to the law, disregard the Constitution, or conformably to the Constitution, disregard the law. The court must determine which of these conflicting rules govern the case. This is the very essence of judicial duty. So Chief Justice Marshall made it very clear. It is the Supreme Court who determines what the law is. So now that we know it is the Supreme Court who's going to determine what these unwritten rules are, how do they do it? How do they determine what these unwritten or unenumerated rights are? Well, the Supreme Court gives us a test. It's called the Palco test, from a case, Palco v. Connecticut, in 1937. Now, Justice Benjamin Cardozo, one of the greatest jurors in American history, came up with this test to determine if a right be fundamental or not. In Palco, Cardozo wrote, first, we're looking at rights that can be deemed fundamental or implicit in the concept of ordered liberty, or if the rights are the essence of a scheme of ordered liberty. To abolish them is to violate a principle of justice so rooted in the traditions and the conscience of our people as to be ranked as fundamental. Now, that language from 1937 may be a little complex for us in 2022. So here is the test in today's language. First, we look to see if the principle is so rooted in tradition and conscious of our people as to be ranked as fundamental. And this, the court looks at a historical perspective. Or if the right that we're talking about is implicit in the concept of ordered liberty. Now, this means the right we're talking about is necessary to exercise an enumerated right. And in this case, the court must show that the right is somehow implicit in the constitutional text. And if the court finds either one of these elements satisfied, then we have a fundamental right. So we have written, enumerated rights, and unwritten, unenumerated rights. And how do we determine that? Through the Palco test. So this is the scheme in which the Supreme Court uses to determine what rights are applicable to the people. Either they're in the Constitution or they're not. So when a new right is proposed, the court is first going to see if it's enumerated in the Constitution, and if it's not, the court is going to see if it's an unenumerated right, and that will be determined by employing the Palco test. Now, in Roe v. Wade, the right to abortion is an unenumerated right, and as such, the court in Roe v. Wade ran it through the Palco test. Here, these decisions make it clear that only personal rights can be deemed fundamental or implicit in our concept of ordered liberty. Palco v. Connecticut. And even the Dobbs Court, in overturning Roe, used the Palco test. Here, the court has long asked whether the right is deeply rooted in our history and tradition, and whether it is essential to our nation's scheme of ordered liberty. Now here, Palco is not directly cited, but if you look closer, here at footnote 19, well, that footnote shows you that this is the Palco test. A right is among those fundamental principles of liberty and justice which lie at the base of our civil and political institutions. Palco v. Connecticut, requiring a principle of justice so rooted in the traditions and conscience of our people as to be ranked as fundamental. So now we know the scheme in which the Supreme Court determines if rights, especially unwritten rights, are within the Constitution. So now we know that both Roe v. Wade and Dobbs v. Jackson, the case overturning Roe v. Wade, both employed the Palco test and came out to very different conclusions for very different reasons. Let's start with Roe v. Wade. How did they overcome the Palco test? Well, first, Roe v. Wade points to the Constitution does not implicitly mention any right to privacy. So, in our scheme, we're not talking about an enumerated right. We are talking about an unenumerated right, and it must pass the Palco test. So the court in Roe starts with the second element of Palco, whether it's implicit in our concept of ordered liberty, necessary to exercise an enumerated right, and the court must show that the right that they deem fundamental is implicit within the constitutional text. And the court in Roe v. Wade gives us some examples of this. First, they point to Stanley v. Georgia, 1969. In Stanley v. Georgia, Supreme Court Justice Thurgood Marshall writes the opinion for a unanimous court. The court held that the First and 14th Amendments prohibited making private possessions of obscene materials a crime. In his majority opinion, Justice Marshall noted that the rights to receive information and to personal privacy were fundamental to a free society. Marshall then found that if the First Amendment means anything, it means that a state has no business telling a man sitting alone in his home what books he may read or what films he may watch. The Roe Court points to this personal privacy were fundamental to a free society and that this privacy is necessary to exercise your First Amendment rights. So in Stanley v. Georgia, to exercise your First Amendment right, you need this privacy right, which was unenumerated in the Constitution. So in Stanley v. Georgia, this right passed the second element of PALCO. It was implicit in the constitutional text. Another example they give is Katz v. United States. Now, Katz was a case about the Fourth Amendment's prohibition against unreasonable search and seizure. And here's what the court said. And wherever an individual may harbor a reasonable expectation of privacy, he is entitled to be free from unreasonable government intrusion. And again, we see the word privacy. So where Stanley v. Georgia relied on the First Amendment, Katz v. United States relies on the Fourth. And again, they satisfy the second element of the PALCO test, making the right to privacy within the Fourth Amendment an unenumerated, constitutionally protected right. Now let's turn to Roe. In Roe, there is no amendment or right implicit in the Constitution that the court points to at Roe, but still it finds the right to privacy to be an unenumerated right. So, based on the PALCO test, the second element doesn't apply to the right to have an abortion under Roe v. Wade. None of the amendments or rights found within the Constitution implicitly gives a woman the right to have an abortion. So where Stanley v. Georgia relied on the First Amendment and Katz v. United States relied on the Fourth Amendment, Roe v. Wade relies on none. Now, this is not fatal because just because Roe doesn't satisfy the second element, it can satisfy the first element and still be deemed constitutionally protected. Now, the court in Dobbs v. Jackson, which overturned Roe, pointed to this exact problem within the holding of Roe v. Wade. The court writes, Roe found that the Constitution implicitly conferred a right to obtain an abortion, but it failed to ground its decision in text, history, or precedent. It relied on an erroneous historical narrative. It devoted great attention and presumably relied on matters that have no bearing on the meaning of the Constitution. It disregarded the fundamental difference between the precedent on which it relied and the question before the court. So the Dobbs court said, implicit in that concept of order, liberty, or implicit in somewhere in the constitutional text, we don't got. But let's look at whether it's rooted in our traditions and conscience. So Roe does speak to the first element. So the Roe court then makes the argument that the right to an abortion is rooted in our traditions and conscience. And this is the support they point to. Let me put it in bullet point form. So, the Roe Court points to the penumbras of the Bill of Rights, Griswold v. Connecticut from 1965, the Ninth Amendment, and the concept of liberty in the 14th Amendment. Now, Griswold v. Connecticut was a case decided by the court 8 years before Roe. It was a 7-2 decision, and the court found that the right to privacy can be inferred from several amendments in the Bill of Rights. And this right prevents states from making the use of contraception by married couples illegal. The Griswold court found an inherent right to privacy in the Constitution. Now, the Griswold court applied the PALCO test and found that, hey, this is implicit in our concept of ordered liberty, and you must have the right to privacy to exercise the enumerated rights in the Constitution. And then the court turned around and used Griswold v. Connecticut in 1965 as precedent for Roe in 1973. Then Roe in 1973, to pass the PALCO test, used Griswold v. Connecticut as the principle to show that we had a long tradition and conscience for our people that the right to an abortion should be ranked as fundamental. So this was the Roe Court's reasoning on why the right to an abortion should pass the PALCO test and should be a fundamental right. But the current Supreme Court then decided to reevaluate Roe using Palco again to see if that reasoning holds out. So the court looked at the history and whether the principle is so rooted in the tradition and conscience of our people. And it found that no, it's not. Because abortion laws in the United States prior to Roe v. Wade, the majority of states found abortion to be illegal and had laws against the practice, going all the way back to the beginning of our country. So we had a long tradition about abortion, but that tradition was keeping it illegal and not allowing for the practice. So the court said, as to the first element of the Palco test, abortion is not deeply rooted in our traditions. Matter of fact, it's the opposite way around. And then the court went to look to see if it was necessary to exercise an enumerated right. And the court found that's also not true either. So when the court ran Roe v. Wade, or the right to an abortion, through the Palco test to see if it's a protected, unenumerated constitutional right, the court found it's not. Now, because Roe v. Wade failed the Palco test, the court overturned the ruling. So the question of the day: did the Roe court get it right, or did the Dobbs court get it right? Let me know in the comment section how you feel, and thanks again for watching this. My name is Nate the Lawyer, and I'll see you next time. Peace.